SJC-10493, 9495 with SJC-10600, 601, 602. Picciotto versus the Appeals Court and others.
Good morning, Ms. Picciotto.
Good morning, Your Honor, and other honorable members of this court. As a preliminary matter, I was given by the clerk's office notice that Justice Spina was going to be joining the quorum today, and I would like to register my objection to that on the record.
I've noted your objection. Thank you.
My understanding is that I'm entitled to an appellate panel as opposed to a motion for reconsideration, and I think that Justice Spina's presence on the court at this point turns it more into a motion for reconsideration. But that said, thank you. With me today is Governor's Counselor Devaney, who Your Honors may remember, recognized from your days appearing before her. She would like to address the court with respect to the representations that were made by Associate Justice Botsford when Associate Justice Botsford appeared before her. As you know, when appearing before the
Ms. Picciotto, I'm afraid we do not hear oral argument ever in any case of people who submit amicus briefs.
Okay. Well, I appreciate that is your position. I will say that when she was appearing before the Governor's Council, Justice Botsford testified that she would recuse herself from my case.
Ms. Picciotto, do you have a transcript of that proceeding?
It is before you. It is it's in the record, and if you're having difficulty locating it, I can send another copy to the court.
Of the Governor's Council proceeding?
Correct. I believe that Justice Cordy was present at that hearing. That is my recollection, and it was a little while ago. I thought I saw you in the back of the room out of the corner of my eye. But certainly,
we have a transcript of Justice Botsford's testimony.
Absolutely, yes. Okay. And if the court is having difficulty locating that, I can provide the court with another copy of it. She testified before the council that she would recuse herself because I had testified in opposition to her confirmation. I testified at the council that time that the highest court in the state should not be available in exchange for illegal campaign contributions made to the governor. I was very disturbed by the press's report of that. She, at that time, made affirmative representations to the Governor's Council that that was an error and that she was not aware of it. And she said that she would nonetheless recuse herself from my case because I did not believe that it was an error. Her husband's an attorney, and I don't think that making campaign contributions to the person who's appointing you, particularly illegal campaign contributions, is appropriate. When she was confirmed, she refused to recuse herself, and she used her position to block my discretionary review process of this court. The misconduct and retaliation of Justice Botsford in the instant case has had a direct prejudicial effect, not just for me, but a widespread chilling effect on the public's ability to participate in the confirmation process, as Justice Botsford has set the precedent that if a member of the public speaks out against a nominee, they can expect retaliation once a judge is confirmed, which is why I believe Governor's Counselor Devaney would like to speak with you, not simply as with respect to how it impacts this case, but how it impacts the public's perception of whether or not they can participate in the process. Therefore, in the interest of the public, and to set the appropriate standards for the lower courts, I request as Governor's Counselor Devaney that this court issue an opinion that the failure to recuse on the part of Justice Botsford was inappropriate. I would like to take the opportunity to remind the court that the factual record before you is not in dispute. The facts are uncontested. The respondents have repeatedly had the opportunity to challenge them, and they have this court must assume at this point that there was a substantial miscarriage of justice in this case. The respondents do not dispute that the underlying judgment violated due process. They argue that a void judgment should acquire validity through laches. This court has held in Harris v. Sinella case that a judgment that violates due process never acquires validity. The undisputed facts of this case are Plaintiff Costello had a private meeting with a sitting judge and bribed him, Appendix 73 to 82. The plaintiff who bribed the judge was rewarded by that same judge with $3 million of punitive interest in direct violation of the rules of court and over 200 years of common law, both in the Commonwealth and in the country, which state that money on deposit with the court register cannot accrue punitive interest against it. This case stands alone in America. Never has such a fraud been allowed to occur in this country. It was a robbery without a gun, and it was a theft of millions of dollars for friends of this court's friends and insiders. This case stands alone in America as the only case where jurors wore Halloween costumes.
Excuse me, what is the relevance of that case to this proceeding?
What is the relevance? That's what's before you. That is what the nature of this proceeding is I'm asking this court to issue writ because the lower court engaged in such egregious misconduct that was absolutely unaddressed. The appeals court chose to deal with it by pretending that Plaintiff Costello wasn't a plaintiff, that the guy that got the $3 million in his pocket wasn't the plaintiff, that he was tangentially related to the case.
Excuse me. What is your relationship to that case?
I was a party to that case. I was a defendant. I was the person that settled with Travelers for $9 million and ended up with a $1.5 million debt.
Ms. Picciotto, excuse me. Is that case in front of us now?
This case before you is with respect to the writ of certiorari, asking this court to issue writ because the...
No, is that case in front of us now?
That case is before you now because the relief that I'm requesting is that this court issue writ and compel either one of two things, that the appeals court issue a finding based on the actual facts of the case, the fact of the case being that Costello was a plaintiff to the case, that he's on deposition saying, I met with the judge ex parte during the pendency of the action. I met and I offered him a prestigious social position. I understand that things are fast and loose in Massachusetts now, and unless the feds come in and say you can't stuff money in people's underwear, apparently it's our right to meet ex parte with judges, and apparently it's our right to give illegal campaign contributions to the governor. But I think that it's a travesty. I think it's a travesty that the money was on deposit with the court register, and interest was accrued against it. Judge Sikora accepted in rem interpleader jurisdiction, in rem, over the property. I shouldn't have to tell your honors what that means. And then he said, without divesting myself of the rem, I'm not going to follow the rules of interpleader law or Rule 22 going back to 200 years. I'm going to throw an additional $3 million to the person who met ex parte with me, and this judge refused to recuse himself. This case stands alone as the only case where counsel for the plaintiff, Robert V. Costello's counsel, passed joke bumper stickers to the jury, that he encouraged the jury to participate in the creation of a cast list over who would play who in the movie, all with the blessing of the trial judge. And your honors may be aware of it because it was reported in the press. It was a circus.
Was this all presented to the appeals court in the direct appeal?
It was presented to the appeals court in the direct appeal. What the appeals court did is said, hey, a lot of the tapes have gone missing. We don't know where they went. We don't know where the record in this case was because half of it ended up in the wastebasket. And Plaintiff Costello, we're going to pretend he wasn't a plaintiff. We're going to pretend he wasn't a plaintiff. It is an outrage. And I'm asking that if this court wants to say that it's okay for the chair of the BBO, the official enforcement arm of this body, to come into the judge's private lair and start offering him quid pro quo, then put it on the record, say, hey, Dumoulis v. Dumoulis, it's okay to bribe the judge via proxy, wine and dine him, invite them where you wish. Now we're going to set a new standard in Massachusetts. You can do it in person as a plaintiff. But at least put it on the record and be honest about it. This is the guy that got the $3 million. The The question before the court at this point is, is there an available remedy for this level of egregious due process violation? The respondents argue that there should not be, and that the injustice should stand. Their argument is essentially that discretionary review made unavailable to me should be considered as a matter of law to have been made available to me. And I say that that is an unacceptable legal fiction, okay?
Now, this court denied further appellate review?
That denied me the opportunity of further appellate review, and I would say that that process was, I think that that was an error. I think I should have been allowed further appellate review because there should be a decision on the facts of this case, not made-up facts. I
think we just denied the application for further appellate review, correct?
You denied the application. You did not give me the opportunity to brief it, and I would say
that's what our rules are that apply to every single person.
Did you file a petition for certiorari with the United States Supreme Court?
I have not yet, because I do not have an accurate factual record to give them, because the appeals court pretended that the plaintiff was not a plaintiff, that the fellow bribing the judge was not the party getting the money. And I would suggest, Your Honors, that I deserve a decision based upon the facts of the case, and I would suggest to Your Honors that that discretionary review that's denied to me is not an appropriate appellate remedy. I would also say that, Your Honors, that, pardon me, that this court has a duty to oversee, not just has a duty to give me a fair hearing based upon the actual facts of the case, and also has a further duty to observe the lower court's behavior and make sure that they're not engaging in these this kind of misconduct. I think that there's a public perception, and it's not just me, and it's not just crazy Melita Picciotto out there, that there's something very, very awry with our court system in Massachusetts, that things have gotten a little bit off kilter since the days of Justice Liakos. And I would like to return to a time when the public could be ensured that they would get a fair trial, that they would not have their property stolen from them, and they would not get a situation where it was such a revelry. The theft was such a revelry that people wore costumes.
Ms. Picciotto, thank you. Your time is up.
Thank you.